Shut that door. Thank you. Good morning, Mr. Rand.
Hey, buddy.
How are you?
I'm good. I don't see you. Are you on phone?
No.
Okay, then you need to push your little, somewhere on your screen is video. So you got to poke that, Mike, because you've got a red light right now. There we go. Look at you. You're a tech genius, baby.
Yeah, you better enjoy it today because it won't work tomorrow.
Mike, I was going to say tilt your camera so we can get your head. We got you, buddy. Yeah. So this will be an interesting discussion, Mike. A lawyer on the other side talking about insurance.
Hey, it's a contract written by lawyers, interpreted by lawyers.
Hey, you know what? We're just standing on the sidelines, buddy.
Yep,
That's all we can do. Stand on the sidelines and let those guys throw punches. That's all we can do.
Yep, indeed.
So Tony's coming in. Hey, Tony, the head has arrived. Oh, man, you're messing it up, man. I'm just used to the top of your head. We're going to have that tips video and talk about what's in the background. What is that in the back there, Tony? You're a ghost? Hey, you need to unmute. We cannot hear you.
That is my wife's separation, kind of like a little barrier thing.
Okay. Look, I don't want to know why you're separating from
and my hat and my rain jacket.
Too much.
Well, I'm at home. I'm not at the office today.
Mm-hmm. Yeah. I got nothing, man. I got nothing.
So I'm actually going to be on this computer over here.
Yeah.
So I didn't set this one up for how I like to look at it. Because normally I like that angle. If it faces forward, if my computer faces forward like this, it has a bad reflection on it. So I like to keep it like that. We got Bill on yet?
Here's Mr. Wagner. Mr. Wagner, good to see you. My name is Keith Rand.
Good morning.
Good morning, sir. Good morning. We'll give this thing a couple of more minutes, but we'll get rolling and not tie your time up. Okay. I see. Hopefully, you can see at least 4 heads, one of which is Tony. I hope.
Yes.
Okay. Good. So we'll do some
for radio.
Yeah, he keeps saying that. I have nothing to do with that. We'll give this thing a couple more minutes and then we'll get rolling. Some people drag in a little later, Mr. Wagner, so we might get some joinees, but we try to be pretty prompt with this thing here. So we'll get rolling here in a minute. So anybody got anything exciting business-wise that happened this week? Rhoda, I know you had some real people involved, right?
I did. I had my first in-person business meetings. And
good.
Walked into the building with mask on, of course. And
right.
Then in this particular, either one of the companies, no one was wearing a mask indoors. And there was some degree of distancing, but that was it.
Huh. Yeah, I'm sure that all versions of this will be applied everywhere. So
I went to the Indy 11 game on Saturday night. And,
oh yeah?
Yeah. And it was pretty sparse, like really sparse. Even the Brickyard Battalion section was really sparse, which I thought might actually fill up reasonably well. My 2 boys and I went, so it was kind of interesting. They only had 2 areas where you could buy beer and food open, and frankly, they were not very well. They didn't even need them just because people weren't really doing anything.
I don't know what to say. Hey, let's get rolling here. I know 2 people told me they were going to be late, so we're not gonna hold them up. We'll introduce them as we go along. Hey, Mr. Wagner, just so you know, what we do is we normally go round robin, introduce ourselves, and so what I'll do is I'll ask the people to introduce themselves according to my screen here. So we'll start with Rhoda. Rhoda, if you'll introduce yourself, let's give us about a minute or so.
Good morning, Mr. Wagner. I'm
Morning.
Rhoda Krilov, and I now run a company called Say It For You and do a lot of ghostwriting of blogs for attorneys, actually. And that's my specialty, but I have a team of ghostwriters, and we write for retailers and practitioners and organizations. So we say it for you.
Very good.
Mike, if you'll introduce yourself.
Hi, good morning. I'm Mike Chambers. I'm an independent insurance agent with Central Insurance Associates. We're up on the north side.
My name is Keith Rand. I own a company called First Quality Printing, and I sometimes coordinate these fine group of individuals for our Zoom meetings. Tony?
Bill already knows me, but Tony Havix with PH2 Environmental. We do environmental health and safety consulting and forensic engineering. And as a kind of a notice, Bill and I go back about 17 years.
Oh, wow.
And working on a case way back when. So I've known Bill for a number of years.
Great. Mr. Wagner, I'll have you hold up for a little bit to introduce yourself as you get your topic, if you don't mind. We normally spend a little bit of time talking about what's going on in our business, in our lives, et cetera, et cetera. So it's been real interesting, obviously, with all kinds of things going on, and in terms of business. Are any of you guys flying airports? I know, Tony, are you going to airports at all?
I have not been. I've had several people who've actually gotten on airplanes and said it was very easy because there was basically nobody around. I can tell you that I talked to a client of mine down in Florida yesterday, and or the Orlando airport was doing an expansion, and they just shut down the construction. They basically turned off the next phase of construction and said they're probably not going to do it for. It's probably going to be put off for a couple of years now.
Yeah, I've taken 3 airplanes. Boy, airplanes are. I'm not sure how long that is a sustainable business model. Flying 1/3 empty. But more importantly, the impact on the retail areas of airports is crazy. I think I mentioned last week, one of my big clients is Indianapolis Airport, and that thing is a ghost town in terms at the retail level. It'll be real interesting to see how long that particular business model can survive. I think the vendors who might have best lines of credit are going to be able to survive. I'm not sure how these other smaller ones are going to survive. So that'll be really, really interesting, because the airport I'm flying back and forth to is the Atlanta airport, Hartsfield, which is the largest airport in the world. And that thing has a significant impact on the economy of Atlanta. So I'm not sure how this works. We'll see how it works, but to me, it's very, very challenging on an economic standpoint to have that business model, and I'm not sure how long that's sustainable. But we'll see. Maybe there'll be some federal money thrown at them. I don't know. We'll find out. So,
hey Keith.
Yes, sir.
Supposedly Atlanta is now not the biggest one because they've dropped so much in numbers. I'm trying to remember who it was. Someplace out west is actually now the biggest one.
Be Denver? Would be Denver?
It's not Denver. No, it's not Denver. I think it's Texas. I think it's one of the ones. I think
Texas?
it's probably DFW. I think is what it is. But I mean,
Yeah.
Indy's at
it's
least
a huge.
yeah. Indy's
It's
at least.
It's a crazy operation. It's crazy. So
Indy's at least buffered for the airport itself by having FedEx, and FedEx is still continuing with their expansion. They're building a whole new building, and this is going to be basically their corporate hub, and they use this as their tryout for all the other airports in terms of how they manage logistics and the like.
Right. Mike, you were getting ready to say something?
Keith, did they have the passengers on the plane spaced out pretty well?
Absolutely. If you were in that, but it was odd. if you were in a triple, there was no one in the middle. But if you were doubles, they let you sit beside each other. Don't I don't understand. But if you were in a three, triple, and if you're in first class, no, they sat right next to each other like they normally did, which I thought was kind of odd also.
So did
But
you
the
have
one,
people, did you have people in the seats behind you and in front of you?
yes, yes. The only actual spacing was in the side by sides. But I'll tell you something that did make sense to me. Is they load the back of the plane first, which I have always said. This is the stupidest way to do any logistics, is to cram all the people who have luggage and stuff, and you're stalled. So now by loading the back of the plane first, it's a much more efficient process. And first class, if you're first class, you can go on anytime. But for the rest of us civilians, you go in backwards, which is, I just don't understand why that just doesn't make sense. And I hope that's one thing that they keep as we move forward here. So we'll find out about that. So
Hey
it's
Keith,
weird.
as you talk about how they set up the plane, so for Indy 11 game, you have to buy the tickets ahead of time, and they have them in groups of 3, 4, 2, and 1, and you have to buy that whole group. So
Mm.
when you choose your seats, if it's a group of 3, you're buying 3. If it's
Oh,
1,
wow.
you're buying 1. I guess they want you, if you're already in together, they'll let you stay together, but they don't want different people next to one
Mhm.
another. And so
Right.
they had the section spread out pretty well, actually, in terms of
Hmm.
what was available. Of course, they didn't necessarily need to, because not a lot of people came to the game.
So
Right.
you're
Right.
paying for 3 seats, Tony?
I paid for 3 seats because I took my 2 boys with me. So I selected 3 seats because I had
Oh.
myself and my 2 boys. If I was by myself, I would have selected a 1-seat location.
Mhm. I had an interesting experiment on Sunday night. They opened the Continental Dance Club dance, and I was there for the first time on the door. So think about this. The facility, the Starlight Ballroom, holds 268 people. There were 28 people in attendance total. And of course, they danced together, touching, but with masks on. So it's kind of Kafkaesque picture of a compromise. They had lots of hand sanitizer, and all the tables and chairs had been scrubbed down by us, the board, before the event. And but still, we were dancing with different people, so it was an interesting
It's
experiment.
different masquerade ball.
So dancing is considered a contact sport, but apparently that was within the rules.
Rhoda,
But
you now have a big germ pod.
I got nothing for this group, Bill. I got nothing. As you can see, we're rather eclectic here. Hey, the other thing that I just want to spend a minute or two discussing before we let Mr. Wagner on here is this issue with sports. This is a multi-billion dollar, again, this is a multi-billion dollar industry in America. And not just the sports, but everything that surrounds it, restaurants, events, et cetera, et cetera, et cetera. I'm not clear how that process moves forward, particularly at the school level, whether it's high school or whether it's collegiate. Had an in-depth discussion with a friend of mine in terms of uh, exposure, student athletes exposing, and the liabilities of schools, potential liabilities of schools to athletes whose careers may be affected by allowing them to play. And it's just fascinating to me. You get these multi-million-dollar coaches and multi-hundred-million-dollar, the big schools. The small schools don't make no money, but who are encouraging these athletes to play, but they're still playing for peanuts. I'm just finding this a whole fascinating discussion, and just Tony, you and I were both collegiate athletes, and so I don't know what do you think about that?
Well, I think right now everybody who's an athlete is getting basically the raw end of the deal because you've got you don't have a good mechanism to work your way up and make money, and now with the cash revenue that comes from stadiums isn't a lot, but it also feeds everything else.
Right.
It feeds the purchases and everything else, and so even though it's a multi-billion-dollar industry, I just don't see it sustaining itself the way it needs to sustain itself without actually having people get together. And the athletes who are now, whether they're in college or whether they're in pros, are going to be taking a beating. And it's coming because they're going to basically start having to renegotiate stuff. But the colleges, I know they're going to play, man. They're going to play because they need that money. They need some money because the colleges are hurting right now. Because I've been talking to a few colleges representatives, and they're saying their revenues are down. They're looking at cutting off some admin positions, which is not surprising because look at the revenue of most of these cities. They're way down. They're looking at raising taxes and bumping them up to try and compete, but nobody's got the money to pay.
Yeah, I don't know. I'm just thinking, having been a collegiate athlete, that your career is so short, right? Everybody talks about going to the pros. Very few. It's a very tiny amount of athletes that go to the pros. And so if you don't get an opportunity to do what you do, luckily they are continuing in scholarships, but I can see a situation where scholarships may be contingency. And that's not good. That's not good. You ask the athlete to risk it and it's contingent. I tell you, that's a concern of mine. That's a bit of a concern of mine. So we'll keep a monitor on that and see. Uh, let's keep it moving here. Mr. Wagner, I keep calling you Mr. Wagner. What would you like to be called?
Yeah, you can call me Bill.
Hey, Bill, no problem, sir. Thank you so much. First off, thanks for coming and speaking to us. And Tony, thanks for getting me. We have had some in-depth discussions about this insurance issue and these liabilities with that. So to get somebody who's involved in it on the legal side is really interesting to me. A couple of things before we move forward. We record these meetings and we send them to our other members who can't make these events. Like I'm off next week, so I did want to give you a heads up on that. So with that being said, what I'd like to do is you just go ahead, give us a little bit of introduction to yourself, and you can begin what we're going to talk about. Tony, unless you want to do his introduction, you can let Mr. Wagner do it himself. It's up to you.
I'd let him do it. I'd let him do it himself. Bill's a good guy. He's a Valpo guy, which Valpo
he's
Law
a good
School
guy. He's a lawyer, man.
Well, he's actually one of the good guys. I have to say. Yeah, a lot of
Just know
lawyers
where
are.
you're sitting, Tony.
But he's a Valpo grad. He's been practicing. He's practiced federal, state, multiple districts and multiple locations, as well as pretty broad-based litigation background in terms of cases that he's worked on, environmental insurance, even outside of that. And so, with that kind of, Bill's got some of the business acumen as well as some of the legal acumen to be able to take an interesting approach. And he's looked at some very ingenuity-wise ways of using the law. And so hopefully we'll talk about a couple of those with regard to COVID-19.
Sure. And let me know if you can't hear me well. I've got a new speaker, so.
No, you're sounding very good.
Oh, great. So, as you were talking earlier, we're aware that the city of the Indianapolis airport has pursued a business interruption civil authority claim for insurance coverage as a result of executive orders and local health department orders shutting down their business. We're aware that local sports teams have also pursued this type of claims. And restaurants, theaters, a whole group of policyholders who were affected by the executive orders that basically shut down their business. And so if you go back around March 15, March 16 of this year, that's when a lot of the governors started issuing executive orders saying that the COVID virus was causing personal injury, property damage, and in many places had been declared a disaster. And they imposed orders across the state shutting down those businesses. And then there were a couple unique issues that came with this virus. The first one was no one really knew how long it would stay on a surface. There were some studies that said that looking at SARS when it first broke out in 2003, that said it would stay on a surface up to 28 days. And Tony brought to my attention that that was in a particular unique circumstance where it was a cold environment and it was on, I believe, stainless steel. But the other issue is there was a study from CDC that was published around March 28 that said that they had done some studies of cruise liners and showed that the cruise liners, the virus had stayed, was found 17 days after the last passengers had departed. So they were doing swab tests and they were finding the virus on those surfaces. The other aspect of this was that you had asymptomatic people who could spread the virus. So right now there's some studies that say that up to 40% of the people who get the virus will be asymptomatic. So you could have someone come into a place of business, a restaurant, sneeze, cough, or just in the matter of talking, express the virus on a surface, and it could be there. Someone else could touch it, touch their eye, touch their mouth, and that's how it spreads. The other unique aspect of this is you really don't know how much of the virus you need to be exposed to before it starts to multiply in your body. So even though you're exposed to a small amount, a droplet, once it gets in your body, then the virus could begin replicating itself. And the other thing that we noticed is there were many insurers who were saying that, you know, the virus is not causing structural damage. It's you can wipe it off with household disinfectants, and that became true, became reportable sometime after the end of March, beginning of April. That's when people really started to talk about that ability to clean up the surface. But how well, you know, how do you know that you cleaned up a surface well to get rid of the virus? Unless you know, use some sort of fluorescent dye or some other indication to show how well you wipe down the surface. So you had all these different issues happening. And we had clients, restaurant businesses in particular, that were severely impacted by these orders, because you not only had executive orders shutting down the business, except for takeout maybe, but you had local health department orders that were mandating closures as well. And you had schools, movie theaters, on and on. And so we started to look at insurance policies. In Indiana, we have a robust area of insurance coverage for environmental contaminants. For example, a case Tony and I worked on, 15, 17 years ago, it was one in West Lafayette where a roofer had installed a new roofing shingles on a commercial building by drilling through the underlying roof and simply fastening the new plates over the existing roof. Well, in the process of doing this, dust came down and covered a manufacturing facility's business, all their equipment inside the business. And we had to retain Tony to do microscopic examination of the dust particles to determine whether or not those contained asbestos. And it's sort of the same argument that you had in this case, where the insurers were saying, you know, it's just dust. It's not a structural damage to the material inside the business itself. It's something that can be wiped off and cleaned. And we argued that that was a insured event because it resulted in property damage. Property damage under many policies, those were commercial liability policies, like when some third party is suing you, describe are triggered when there is a direct physical loss of or damage to the covered property. And we said the direct physical loss was the dust, and that rendered the property not usable for its intended purpose. No one could go in there and start working on the machines until the asbestos was removed, asbestos being a toxic substance. And we've, my practice for the most part for the past 25 years has been environmental law and insurance coverage. And Indiana has a very good insurance coverage law with respect to if it's an accidental loss. As to the person whose property was damaged in the facility in Lafayette, it was an accident as to them. They didn't intend for this dust to come onto their property. It was a fortuitous event. It wasn't intentional, and therefore there was coverage. Well, you look at that scenario, you look at other cases in the environmental field. For example, if you have a leaking underground storage tank, like a nearby gas station or dry cleaner, you'll have contaminants migrate through the ground, water, through the soil, and then vaporize. So like if you're going to the gas station and you pump gas and you accidentally drop some gasoline on the concrete, it'll suddenly disappear, it'll just vaporize. Well, the same thing happens with the contaminants as they go underground. And they then get underneath the structure of a building, come into the building through vapor intrusion, and then you suddenly have this contaminant within the building. And the insurance coverage law is pretty good that is a covered event. That is property damage through the contaminant vapors coming in. So we looked at all this case law, and you know the presence of the virus is similar under commercial property insurance policies, not liability policies, but these are the policies that you buy to protect your business. You'll have business interruption insurance and then civil authority coverage. And those are the claims that we're pursuing under. And by way of disclosure, we represent restaurants in 2 class actions in Illinois, one against Society Insurance and one against Cincinnati Insurance. So going back in time, around 2003, when the first SARS virus came through, many insurance companies started to adopt a virus exclusion that said if your loss results from the presence of, it was a virus, bacteria, or mold that could result in personal injury or property damage, then there was no coverage for that. Well, Society Insurance and Cincinnati Insurance, and there's a handful of other insurance companies that did not incorporate that exclusion into their policies. So we're looking at this and saying, okay, this, to the extent that you have a virus in your restaurant, and how do we know if that's true? Well, one, we could have someone like Tony, a certified industrial hygienist, come in and do a swab test, just like you see the swab test for your nose, to determine whether or not a virus is present. The other thing that we're arguing is to the extent that you have employees or customers who've reported that they have had exposure to the virus or they have the virus, then how do you know that that hasn't occurred within the restaurant itself? So under the business interruption part of your policy, it says we will pay for direct physical loss of or damage to covered property. And then it talks about the loss that's recoverable. It's usually your business income, meaning your net lost profits, plus continuing expenses like payroll, rent, insurance, those type of things, taxes. So if there is coverage, it's going to pay for those type of expenses while you're closed. And we have argued that the direct physical loss of or damage to property is the physical presence of the virus. And it's also, we have argued, loss of use. So for example, in our case in Illinois, Society Insurance has just filed a motion. In another case, they told us they were going to file a motion in our case, where they're arguing that under Illinois law, the term physical in an insurance policy means structural damage. It has to be affect the shape, condition, or structure of the property. It has to be something that's physically damaged. Well, what they're glossing over is that when you have the virus present on the property, it is essentially not usable. It is damaged. It does require cleaning, just like the dust that was on the equipment in West Lafayette, the asbestos dust. When you have the virus present in the restaurant, you then have to clean off the tables, you have to clean off the surfaces, the counters, the door handles. All of that results in property damage. So to the extent that there is, or for example, we have restaurants that were connected to the train stations in Chicago and bus stations. So, and there were, I think, somewhere north of 250 CTA employees who were diagnosed with COVID-19. And unfortunately, some have died from COVID. And so the argument there is, to the extent that they came in the restaurants, and we know that they did, then to that extent, there has been a loss of property damage and a loss of business income as a result. There's another aspect of coverage. It's called civil authority coverage, and that doesn't necessarily require damage to your property. So this coverage really, the cases, if you look at the cases, they all go back to the 1960s and civil unrest in Detroit and other areas where mayors and governors imposed curfews as a result of civil unrest. And they closed movie theaters, were the plaintiffs in these cases. They basically closed their operations for 2 weeks and said, you can't have any patrons for a period of 2 weeks until the riots are over. When you looked at the policies, civil authority coverage doesn't require damage to your property. It says basically if there is damage that is of a type that is covered by your insurance, it's a peril that's covered by your insurance, then that and there's a order that closes your business, that triggers the coverage. And so many of these policies, property insurance policies, cover civil unrest, riots, civil commotion. They also cover, when you look at these policies, many of the commercial policies that we're looking at, like Society Insurance, Cincinnati Insurance, they are all risks policies. They basically cover a risk unless it's specifically excluded. And we are arguing that the damage that has occurred at other restaurants and other locations that have had the virus and that have triggered the executive orders and the local health department orders and the state health department orders and the mayoral orders closing businesses, those have triggered the civil authority coverage. Many of these policies require that the damage be within a certain distance, within 1 mile or within 2 miles or within the immediate area. Many of them begin to cover after a period of 72 hours and then go for a limited time period. The society policy only goes for 30 days. Cincinnati policy, I forget what it goes for, if it's 4 weeks to 6 weeks, or, to the extent it's negotiated something beyond that. But so you're looking at a very short period of time. In our building, for example, I'm at the Union Bank building in downtown, and Union Planners, First Indiana Square. There was across the street at BMO Plaza, there was someone who was an employee that had COVID-19 that was responsible for cleaning up the maintenance, cleaning up the elevator, cleaning door handles, all those things. So therefore, we could pursue a claim if we wanted. We haven't had the loss, but if we wanted to, we could say that there is a loss within a mile of us, and there has been a closure with respect to certain businesses, and that that civil authority coverage has been triggered. So that's the claim that we're pursuing, and it really comes down to the different state laws. For example, there haven't been very many reported decisions on this at all at this point, because the lawsuits were just filed in the end of March and in April. There's been one case that's been reported out of Michigan. On July 2, there was a case, Gavrildes Management Company versus Michigan Insurance Company, where the plaintiff, their policy did have a virus exclusion, and they were arguing that the closure was only resulted from the executive order. And the court looked at it and says, well, there's a virus exclusion, there's no coverage here. And they lost as a result of that. The court added on that you haven't proven a direct physical loss. And under Michigan law, it requires a change to a structural change. That is not a condition under Indiana law. In Illinois law, there is some case law that talks about change in form, shape, or appearance. We think that the presence of the virus results in property damage. It's, for example, when you hear about those grocery stores where someone comes in and sneezes and coughs on the vegetables purposely. That has happened a couple times, and then the grocers throw away all the produce. Well, that's property damage, right? And that's the same thing that we've argued here. And we're aware that there are some class actions being pursued in Indiana. We have not been involved in those. And I know that there's also class actions in Ohio, Florida, Pennsylvania, California. Pennsylvania is unique in the sense that a lot of the, and California as well, a lot of the cases, they're trying to argue around the virus exclusion, saying that it's resulting from an executive order. But I think that's going to be a pushing a rock uphill, I think. If you don't have that virus exclusion, I think you have a much better argument to coverage, because then you can say, this is an all risk policy. You promised to cover all risks. You knew that there was a virus exclusion. Obviously, the rest of the insurance industry thought that a virus could result in property damage and loss of use, because they specifically adopted this exclusion back in 2003 through 2008, and you didn't. So that was a conscious choice that you made, and there should be coverage. So that's the argument that has been made, and it's being made all over the country. There aren't very many reported decisions. On the legislative front, you also have states like Ohio, Pennsylvania, Michigan, and I think there are 5 or 6 others that have passed or proposed legislation to read the virus exclusions out of the policy, to basically say that there should be coverage. So, if you're looking at a business that was closed as a result of the executive order or the actual presence of COVID, I think those businesses ought to be filing claims to protect themselves. And then most policies give the policyholder 1 year or 2 years from the time they submit a claim or the time that they know that they have a claim to file a lawsuit. So, you could file your claim and then just sit back and see how the case law develops and then pursue your claim later. And you might be covered by a class action lawsuit if there's already one being proposed. You just have to make sure, whether or not you opt out. That's a different decision based on every business, depending on the amount of the loss. Go ahead.
Hey, this came up in a discussion with a friend of mine who owns a restaurant, by the by, and you just spoke about this retro exclusion process, in terms of there may be some legislation that would exclude that virus piece of it. Mike, because you're in insurance, I don't get that. How would that work? I couldn't understand how you would protect me from yesterday. I didn't get that. So maybe I just don't know enough about the law and insurance on how that would work. You would protect me from yesterday?
Here's the issue. The issue is whether or not the policy is broad enough to provide that type of coverage. And then there's an argument as far as the impact of contracts, whether or not it's constitutional, whether you can go back and change a policy, change a contract. Some have argued that it's not constitutional to do that. It's unconstitutional to do that. And that issue has not been resolved yet in the courts, but there have been other cases in highly regulated industries like insurance. Every time an insurer, before they can sell insurance within a state, they have to submit the policy form to the Department of Insurance, which then reviews it, determines whether or not it's acceptable. Insurance brokers, insurance agents are all licensed. You have to be licensed to do business as an insurer in Indiana. So there are some arguments that you can go back and adjust that. There are also different states, for example, that have passed legislation allowing carve-outs to the statute of limitations for certain issues. It's a little bit analogous. For example, New York and Illinois passed laws that said they were going to give victims of sexual abuse 1 year to file a lawsuit, even though the statute of limitations may have passed. So you have people who were in the Boy Scouts, people who were members of a church who may be in their 50s and 60s that were a victim of sexual abuse that now have a window to file a lawsuit against these insurance companies. And the argument was, hey, that's not proper. You're changing the terms of the coverage. That's not what the insurance company bargained for. And when you look at the case law says that these insurance policies are strict policies. You really can't negotiate with an insurer on the terms of the policies. You either pay for it and get coverage, or you don't pay for it and you get no coverage. They're contracts of adhesion. So it's take it or leave it. And so when you look at the policies, they're interpreted from the perspective of the average person. What would the average person believe coverage what does the average person believe direct physical loss of or damage to property? What does that mean? And the contracts are also construed against the insurers because they are contracts of adhesion to the extent that there's an ambiguity. And here the argument is, for example, direct physical loss or damage. By including the word loss in that phrase, the insurer must have known that that was something separate and different from the word damage. Otherwise, they could have just said direct physical damage to property, but they included the word loss. So if you suddenly shut down the indoor seating area and bar of my restaurant for its intended purpose, well, that's a loss of use. You have told me I cannot use that part of my property under this executive order because of this damage that has occurred at restaurants and other locations. So that's the argument that we're making. But there is a whole argument about constitutionality. But Mike, you wanted to
So,
chime
Bill,
in?
from that that retroactive aspect of it, in terms of it being retroactive, you know, that I could see. You're right. Insurance is a little different. So when they tried to change the mold exclusions, a lot of that was said, well, you can't just take it out of the policy. So a lot of the insurance companies decided they would just reduce the amount. And so since they've taken a lot of the virus directly out, they have to explain why they took it out in the first place. So you can go back and review the basis for why they took it out of the policy, and if they can show that there was a misrepresentation or it wasn't factually correct in terms of why they took it out, basis for where they took it out, then you can actually challenge that.
Right. Or, you know, they didn't specifically add that exclusion. There's also some legislation afoot where they're talking about creating funds like the terrorism account. You know, so your policy has a provision about terrorism that, you know, there's a pool as far as all insurers get together and pool $100 billion, excuse me, or whatever the number is. And your loss would be charged against that pool. So some insurers, or excuse me, some legislators are proposing that they do something like that, that there would be a pool funded by state funds for small businesses, meaning a business that has 100 or 150 or fewer employees. I believe Massachusetts has 150. I think many of the other states like Ohio is looking at 100 employees as the size of a small business. And if you bought commercial property insurance that has business interruption or civil authority coverage, but it has this virus exclusion, they're thinking, you know, how can we get money to those policyholders? Maybe have the insurers act as claim adjusters for that purpose. You know, they'll process claims by restaurants if they had fewer than 100 employees and determine some amount, you know, how do we value their claim for lost business income? There are a whole bunch of different moving parts at this time. So it's really exciting times.
I guess just from my perspective, I just, you know, I'm not a lawyer and I'm not an insurance guy, but I'm just trying to figure out how liability would move forward and how it would be priced. If I was an insurance company, if now you're telling me that I might have unlimited retroactivity, or there's potential that there may be retroactivity, I think pricing it going forward, I'm gonna shoot for the moon. If that's what I would do, because it's crazy. How would you know? How would you create reserves for that, Mike? I don't know. That sounds weird to me. But once again, I'm not a professional in either one of those areas, so I don't get it. Go ahead, Mike.
Well, I think you're right. I think it's an unknown. It's an unknown number. So yeah, I think, you know, rates are going to go up, and
Yeah,
they're going to, you know, how much? 10%, 20%? Who knows? Who knows?
Well, the
Wow.
flip side of that is that rates may go up, they may not go up, because from this point forward, all the insurers are going to have a virus exclusion, right? Now if you have a small business, now is the only time, if you have one of these policies that doesn't have a virus exclusion, to submit a claim, because many of our clients are already, you know, looking at getting their next policies, and all the policies basically have a virus exclusion, unless, for small businesses, unless you're, you know, you go into a special market and negotiate some sort of virus coverage, pandemic coverage, which some insurers are offering at a premium.
Wow, this is, you know, I just
Bill,
think
do you
from,
want to talk a little bit about workers' comp at all?
Well, there's workers' comp. There are some states that have considered the issue if you have the coronavirus. There is a presumption some states are proposing a law that there would be a presumption that you contracted it at work if you were working. So for example, if you're a hospital employee and you contract coronavirus, well, some states are proposing this, under the workers' comp law, there would be a presumption that you contracted that while working at the hospital as opposed to, going to the store or, being somewhere else. That is subject to a lot of debate. And I don't know, I think there are some states that are proposing that type of legislation or have adopted those rules, like Illinois. But Tony, were you thinking of something in specific?
Yeah, so I know a gal, my daughter's obviously a nurse down in Chattanooga, and she worked with a gal who had COVID-19 twice, and she's been working with patients. And her employer said, you need to take your time off on the first one, and then the second one they gave her paid time off. But in terms of the first time that she had, she took off 2 weeks, got no pay. In reality, that's a workers' comp. That was on the job, loss of pay, loss of money.
And she worked in a hospital, Tony?
Yeah, she did.
Yeah.
Yeah. But
I think it's
and apparently that's the hospital's policy is if they are actually trying to force the employees to use their sick time if they want to get paid.
I would think that somebody that's working in a hospital and gets the COVID, it would be presumed that that's work related. I can't imagine the insurance company denying that.
Given 21% of the cases out there right now are hospital medical personnel, you would think.
Yeah.
I don't know. Wow. Mr. Wagner, we got about 5 more minutes here. First off, this has been fascinating to me. And this retroactive thing, I've had an in-depth discussion with my friend that owns a restaurant. And because I just thought, oh, that's crazy. This makes no sense to me to run a business where you can bill me for yesterday. But I think your example about the sexual claims, now that I've heard it kind of makes sense. But I'm glad I'm not in the restaurant business because that bill is getting ready to go up. I can't imagine how it wasn't. That's my take, and I'm sticking by it. If you got something you want to wrap us up with, I'd appreciate that. No problem.
When you talk about the restaurant industry, I've seen some industry reports that somewhere north of 25% of all restaurants will close as a result of this pandemic. And that's very, very unfortunate because those are all, generally small businesses and people who really work there because of a passion who start those type of businesses. And that's really sad to see. But to the extent that we can help them, we're trying to. But it's unfortunate.
Yeah, it's unfortunate. So, wow, this has been a really informative and fascinating conversation to me, particularly to hear it from the viewpoint of lawyers, of a lawyer who's actually practicing. It's also interesting to hear the relationship of one of my fellow CBN members and see what they do on the ground. I mean, I think I always kind of understood what Tony did, but I think now seeing it as it cross professional pollination here, it gives me a better understanding of Tony, because I had no idea what the hell he did for a living. And now I think I kind of get how it truly interacts. So thank you, Tony. You really did yourself a favor by having this speaker, by the by. I just wanted you to know that.
Well, you always select speakers who make you look good.
Yeah. I can't speak of Tony high enough. Tony's done a great job for us over the years. Yeah, he's worked in many cases.
Right. Sounds like that. Good. So, well, with that, you guys, hey, appreciate all you guys for showing up. I think I got one mystery person. I think it's my wife or somebody. So it was a pretty good conversation, and once again, this will be sent out to all of us, usually before the next meeting. Tony, appreciate it. Mr. Wagner, appreciate it. Rhoda and Mike, glad you guys could come in. Mike, I thought you would be throwing some fire at the lawyer, but it's like, no, I'm good.
Nope.
I don't.
Nope.
I just sell them, Keith. I don't defend them, so it's not a problem.
Yeah, all this stuff is way above my pay grade.
Right, and I understand that. So it's pretty good. Well, I appreciate all you guys coming by. If you'll just do me a favor, I need a smile, Mike. Mr. Wagner, what we do is we send this out, and I always like to have a smiling photo. Sometimes we have depressing conversations, so if you just give me a smile for a second or so, I take a picture of that, and we'll send that out. I'll also make sure, Bill, that you are included on the summary of the recording in case you ever want to use, and you're free to use it. It's nothing. We're not trying to hide nothing. So we have a good time with it. As you can see, we have a pretty good time. And you're also welcome to come back anytime in the future if you choose to. And Zach Fox is late, but we'll let him come.
Really late.
We do appreciate you doing this, and I'm really smarter now than I was before about that insurance thing. I don't think this is a minor thing. I don't know how long this litigation is going to go on and what we're going to do, but I'm not sure what we do with COVID moving forward. I'm not smart enough. Hey, Zach, good to see you. We're getting ready to go off, man, but glad you could make it. But
I'm going to drop off.
Yeah, okay.
Thank you very
Not
much.
a problem. Yeah. All right, we'll see you guys, and we're getting ready to go off here. Zach, you catch it on our review, Zach. It was a very, very interesting discussion in terms of legal liability, potential liability in this COVID issue. So we'll be moving forward next week. I think we've got a speaker planned, so we'll figure it out. So we'll see each other next week. I may not be here. I may be traveling. Everybody take a plane. We need airports working and back up and take care of yourself. Indiana numbers are moving up. For those of you who are concerned about that, I'm not sure what that. I don't know what that means. And then the whole issue of going back to school. That's another thing. We can talk about that in the future moving forward too. So with that, I'm going to say hasta la vista and hopefully see you guys next week. Thank you so much. And just
Thanks,
catch
Keith.
go ahead. Zach, what'd you say?
I said thank you. Sorry, I'm late.
Hey, glad you could make it. So we'll see you guys and we'll see you guys next week. Bye-bye.
Bye.